Today we will be discussing prosecution of private crimes. So, when we say private crimes, what do we mean by it? Okay? So, example, the crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. So, this is provided in your section 5, Rule 110 or 110 of your rules of court. The rule is clear, okay, in your Rule 110. The prosecutor cannot prosecute the case where no complaint is filed by the offended spouse, since concubinage and adultery are considered private crimes. So, the same rule also provides that the action cannot be instituted against one party alone. Okay? It must be instituted against both guilty parties unless one of them is no longer alive. Okay? Ang ibig sabihin nito, si Ana, okay, ay may asawa, si Pedro. Ang kabit ni Pedro, let's just say it's Maria. And Pedro and Maria had a relationship, intimate and sexual relationship. So, here, Anna can file a case. Anna, being the offended spouse, has the right to file a complaint, against not only of Pedro. Hindi lang pwedeng si Pedro, yung asawa niya. Dapat pati si Maria. Hindi rin dapat si Maria only. Okay? Hindi dapat si Maria lang at i-exclude niya si Pedro. Hindi pwedeng ganon. The same or both of the offender or the guilty parties. Okay? There must be a complaint against both. Of course, okay, except na lang kung namatay yung isa sa kanila. Yung offense of adultery and concubinage may not be instituted, okay, if it is shown that the offended party has consented to the offense or has pardoned the offender. So, for example, pinatawad ni Ana si Pedro. Okay? Dahil mahal na mahal niya si Pedro. Okay? O kaya naman, hinahayaan niya. Okay? Hinahayaan niyang umuwi sa babae niya, si Pedro. Binibigyan niya pa ito ng pamasahe papunta doon sa bahay ng kabit niya. So, that is a consent. Okay, of course, with the knowledge, okay, na they have sexual and intimate relationship. Okay, in that case, the offense of adultery and concubinage may not be instituted because of the consent and because of pardon made. Okay, since the rule does not distinguish, the consent or pardon may either be expressed or implied. Hindi kailangang sinabi. Okay? Hindi kailangang tinext o nakasulat. By implication, okay, pwede. You have also your seduction, abduction, and acts of lasciviousness. Okay? For yung cases or crimes of seduction, abduction, and acts of lasciviousness, lagi nyo tong tandaan. Okay? Kung sa adultery and concubinage, isa sa asawa, okay, isa sa mag-asawa ang kailangang mag-file ng case. Kailangan yung asawa. Okay? In here naman, sa seduction, abduction, at acts of lasciviousness, shortcut niyan is ASA. ASA. Acts of lasciviousness, seduction, okay, abduction, ASA. Sa case na ASA, okay, hindi magkakaroon ng prosecution or These offenses shall not be prosecuted except upon a complaint filed by offended party or her parents or grandparents or guardian. Okay? Siyempre, nor in any case if the offender has been expressly pardoned by any one of them. This is provided in your section 5 also of Rule 110. Note that the pardon must be expressly made. Okay? So, pwedeng magkaso yung offended party, yung nanay at tatay niya, yung lolo at lola niya, o kaya yung bantay niya, o yung guardian niya. Except that, kung pinatawad na yung offender expressly. Okay? Kung impliedly, hindi yun pwede. Okay? Because the law expressly provided that the pardon must be expressly made. Okay? It is clear that an implied pardon is not contemplated under this rule. So, okay, if the situation is like this, if the offended party dies, okay, example, na seduce o kaya na abduct o kaya merong acts of lasciviousness done against Maria. Si Maria ang offended party natin. Namatay si Maria. O kaya naman nabaliw si Maria. Okay? Paano kung namatay si Maria o nabaliw si Maria bago siya makapag-file ng complaint? At wala siyang magulang, wala siyang mga lolo at lola, wala siyang kapatid, wala siyang guardian. Sino ang magpa-file ng case? Okay? In this situation, the state shall initiate the criminal action in behalf of Anna. In the order of those who may file the complaint, the state is the last and may only do so in the absence of the persons mentioned. So, ang state, hindi siya basta-bastang makapag-file ng case for ASA, abduction, okay, seduction, and acts of lasciviousness. Dapat, wala mo ng patay na o kaya nabaliw yung offended party, kaya si Ana. Okay, kung wala na si Ana, andyan yung magulang niya. Kung walang magulang, lolo at lola. Kung walang lolo at lola, yung guardian niya. Okay? And kung wala na talaga siyang guardian, yung state na ang magpro-prosecute in her behalf. Also, in your section 5 of Rule 10, the offended party, even if a minor, let's just say 15 years old si Ana, okay, has the right to initiate the prosecution of the offense independently of her parents, grandparents, or guardian, except if she is incompetent or incapable of doing so. So, ang ibig sabihin, kahit na ang offended party ay isang minor de edad, pwede siyang makapag-file, pwede siyang makapag-initiate ng complaint, okay, for ASA. If you remember your RA 7610 as amended, okay? Ano yung RA 7610? It is the Special Protection of Children Against Child Abuse, Exploitation, and Discrimination Act, okay? In your Section 27 of RA 7610, complaints on cases of unlawful acts mentioned in the law committed against children may be filed by the following. Pwede yung offended party who can be, of course, syempre yung minor, yung parents or the guardians, ascendants or collateral relatives within third degree of consanguinity. It can also be filed by a an officer, social worker, or representative of a licensed child caring institution. Pwede ring isang officer or isang social worker of the DSWD. And yung mga kapitan, yung barangay chairman, pwede. And or at least 3 concerned responsible citizens where the violations occurred. Okay, we proceed with the meaning and definition of a complaint and information. A complaint is a sworn written statement charging a person with an offense subscribed by the offended party, any peace officer, or any public officer charged with the enforcement of the law violated. Section 3, Rule 110 of your Rules of Court. Okay? Lagi nyo pong tandaan ng isang complaint ay hindi lang siya isang kasulatan or ang laman lang nito ay mere statement. Okay? It is also a statement charging a person with an offense. Okay? As a statement, meron siyang sworn and written statement. Lagi nyo ring tandaan, hindi lang siya sworn, hindi lang siya written, kundi siya rin ay it is also subscribed. Okay? Only by the person specified in the rule. It can be a peace officer or a public officer. Next one. In whose name and against whom filed. The complaint is not filed in the name of a private person. Okay? Laging tandaan na ang complaint is not filed in the name of a private person. It is filed in the name of the people of the Philippines and is filed against all persons who appears to be responsible for the offense involved. Lagi niyong tandaan na yung victims ng crime, example sa murder, yung namatay, okay, private offended parties have limited roles in criminal cases. Let's just say people of the Philippines versus Pedro Cruz. Ang pinatay ni Pedro Cruz for the crime of murder, it's example, si Juan. Okay? Here, Juan is the private offended party. One now has a limited role in criminal cases. Okay? There are only witnesses. Okay, here si Juan is only now a witness for the prosecution. Mampanin patay na. Okay? Of course, a dead person cannot speak for himself. Okay? Pero by circumstantial evidence, you can. Okay? So here, yung private offended party may not appeal the dismissal of a criminal case or the acquittal of an accused because the aggrieved party is the people of the Philippines. However, the offended party may appeal the civil aspect of the case and may file a special civil action for certiorari, questioning the decision or the action of the court. Okay? So, in that situation, okay, yung private offended party cannot bring the action in the name of the people of the Philippines, but must prosecute the same in his own personal capacity. Ano naman ang isang information? Okay? Anong pinagkaiba po? Okay? An information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. If you notice the definition of a complaint, it is subscribed only by the offended party, peace officer, or public officer. Sa information subscribed by the prosecutor. So, while an information is an accusation in writing, it is not required to be sworn, unlike a complaint. Diba? Sabi ko nga sa inyo, ang complaint kailangang may sworn, it is also written and subscribed. Okay? Sa information daw, hindi kailangang nakasworn. Okay? Because, sabi sa batas, only a public officer described by the rules of court as a prosecutor is authorized to subscribe the information. Siyempre, ano naman ang pagkakapareho nila, ma'am? Ang pagkakapareho po nila is an information is filed in the same manner where the name people of the Philippines, okay, is in the name of the people of the Philippines against all person who appears to be responsible for the offense involved. Okay, again, anong pagkakaiba nila? A complaint must be sworn. Okay? And information, hindi kailangang sworn. It requires no oath. Okay? Kasi ang nakalagay sa batas, it must only be in writing. Next one. Okay? A complaint or information is subscribed by the offended party, any peace officer or public officer. On the other hand, an information is subscribed by the prosecutor. Okay? Anong mangyayari kung merong infirmity of signature in the information? Merong error yung signature sa isang information. Valid pa rin ba ito, ma'am? Okay? Pwede pa rin ba siyang i-file? Okay, ang sabi ng Supreme Court sa case ng Kodja versus Court of Appeals, it is a valid information signed by a competent officer which confers jurisdiction on the court over the person of the accused and the subject matter of the accusation. In consonance with this view, ang infirmity in the information, such as lack of authority of the officer signing, cannot be cured by silence or even by express consent. Okay? Next question, paano natin malalaman kung ang isang complaint or information is sufficient? Okay? Sufficient meaning enough. Ibig sabihin meron siyang paa. Okay, makakalakad dito sa korte, pwedeng i-file. Ano ba dapat ang content? Okay? You read the case of People versus Cañares, GR number 174065, February 18, 2009. And your Rule 110, Section 6 of your Rules of Court. Okay, ang sabi dito, a complaint or information is deemed sufficient if it contains the following. Okay, there are 7. What are these? There are 6. What are the 6 contents? Number 1 is the name of the accused. If the offense is committed by more than one person, all of them shall be included in the complaint or information. Siyempre, let's just say it's committed by a band. Okay? So we indicate the person of Anna, Ben, Christopher, and Danilo. Okay? People of the Philippines versus Anna, Ben, Chris, and Danilo. So, you have to indicate all the names of the offender in the complaint or information. Number 2, the designation of the offense given by statute. Let's just say they committed by a robbery. Okay? So, the offense, criminal case is robbery. Okay? Number 3, the acts or omissions complained of as constituting the offense. You have to indicate all the elements of robbery committed by a band in the complaint. Siyempre, nakalagay dapat doon na there must at least 3 persons who committed that. And of course, si Anna, Ben, Chris, and Danilo. Yung mga elements ng isang robbery. And number 4, you have to indicate the name of the offended party. Let's just say they robbed the property of Mariano. Okay? The offended party, you have to put the facts that the property is owned by Mariano. And next one, number 5, approximate date of the commission of the offense. Nakalagay po dito is approximate date of the commission of the offense. Not exactly the date, but in approximate date only. And of course, you have also the best is to indicate also the time. And lastly, you put the place where the offense was committed, because some crimes, okay, pwede mo siyang i-file whenever one of the elements is committed by in any of the territorial jurisdiction. Example, if one element is committed in Igig and another element is committed in Tugigaraw and another element is committed in Amulong. So anywhere you can file a case, okay, doon sa tatlong municipality na yun. Let's just say let's just make it an example. So a complaint or information is sufficient if it states the name of the accused, the designation of the offense, the acts or omissions complained of, the name of the offended party, the approximate date of commission of the offense, and the place where the offense was committed. So the test for sufficiency of the complaint or information, okay, the test is whether the crime is described in intelligible terms with such particularity as to apprise the accused with reasonable certainty of the charge. Ang ibig sabihin lang nito is dapat clear, it must be sufficient, it must be understood without any uncertainty, okay, on the part of the accused pag binasa sa kanya yung offense. Doon naman tayo sa date of the commission of the offense. Lagi nyo pong tandaan, okay, that it is not necessary to state in the complaint or information the exact date or the precise date the offense was committed. Except when the date of the offense or the commission is a material element. Lagi niyong tandaan na the general rule is hindi kailangan exact date. Pero, as an exemption, kung material element siya doon sa offense, then the date must be exact and precise. Okay? The offense may thus be alleged to have been committed on a date as near as possible to the actual date of its commission. Next one. So, we go to the determination of the nature and character of the crime. The character of the crime is determined hindi sa caption, okay? Hindi rin sa preamble of the information. Hindi rin sa specification ng provision of law. Okay? Hindi sa mga yon. Okay? So, we determine the nature and character of the crime by how? Paano, ma'am? We determine it by the recital of the ultimate facts and circumstances in the information. So, kung ang nakalagay is murder, pero kung babasahin mo yung information, wala namang mga qualifying circumstances para maging isang murder, then the crime can only qualify as homicide. Okay? So, consequently, even if yung designation ng crime in the information was defective, what is controlling is the allegation. Ang importante po is yung nakasulat doon sa complaint, yung laman, yung facts, yung nakalagay. Hindi kailangan yung designation. Okay, hindi kailangan hindi controlling yung designation. What is the controlling is the allegation or the recital of the ultimate facts in the information or the complaint. So, next, how to state the name of the accused. Section 7 of the Rule 110 establishes the following rules in designating the name of the accused. Okay, number 1, the complaint or information must state the name and surname of the accused or any appellation or nickname by which he has been known or is known. Example, People of the Philippines versus Pedro, also known as Kaliwa Kanan, Boy Kaliwa Kanan Cruz. Why Boy Kaliwa Kanan? That is yun doon siya kilala. Kasi siya magnanakaw siya. Okay, magaling siyang magnakaw, kaliwa man o kanan ang gagamitin niyang kamay. So pwede i-indicate mo ba yung AKA niya or also known as o yung tinatawag nating alias? You may indicate it. Okay? Paano naman pag hindi nyo kilala o hindi mo alam yung accused? Okay? Hindi mo alam yung pangalan niya pero alam mo yung mukha niya. Pwede mo siyang describe. Pwede ka bang mag-file ng case? Okay, the answer there is, if the name cannot be ascertained, he must be described under a fictitious name. A description of the accused under a fictitious name must be accompanied by a statement that his true name is unknown. So, if the name of the accused is unknown, you can indicate him in a fictitious name. Example, what is common is your John Doe. Here you can just name him as John Doe, and you have to indicate in the complaint or information that his name is unknown, and you can just describe him. Okay? If later on, his true name is disclosed or nalaman na yung anong tunay niyang pangalan, okay, his true name shall be inserted in the complaint or information and in the records of the case. Okay? Lagi niyong tandaan na in case there is a mistake in the name of the accused, okay, a mistake in the name of the accused, instead na Pedro Cruz, ang nakalagay ay Peter Cruz. Okay? A mistake in the name of the accused is not equivalent and does not necessarily amount to a mistake in the identity of the accused, especially when sufficient evidence is adduced to show that the accused is pointed to as one of the perpetrators of the crime. Okay? Next one. Do you remember that there are two kinds of person, a juridical and a natural person? Let's go with offended party. Okay? How to state the name of the offended party who is a natural person? Example, okay, si Maria Santos. Okay? The complaint or information must state the name and surname of the offended party. Example, Maria Santos. Or any appellation or nickname by which such person has been or is known. Okay? However, if there is no better way of identifying Maria Santos, example, di natin alam na siya si Maria Santos, she must be described also. The same rule. Okay? The same rule will be applied like that of an accused. Okay? Paano naman kung ang offended party is a juridical person? Okay, example, si Jollibee, McDonald's, okay? Example, nasira, libel, nasira na, yung reputation nila is nasira. Okay? If the offended party is a juridical person, example, si Jollibee, it is sufficient to state its name or any or designation by which it is known or which may be identified without the need of averring that it is a juridical person or that it is organized in accordance with law. Okay? This means na ang mahalaga, you just indicate it that it is a juridical being. You just also indicate its name. Example, Jollibee Food Corporation. Okay? It is formed and organized in the Philippines. Okay? Next one. What is the rule naman if the name of the offended party is unknown in offenses against property? Okay? In offenses against property, if the name of the offended party is unknown, the property must be described with particularity as to properly identify the offense charge. Okay? So in this one, in the case, like example, in the case of Sison versus People, GR number L-51745, October 28, 1988. The court ruled that in a case of offenses or in case of offense against property, example, theft, kaya robbery, the designation in the name of the offended party is not absolutely indispensable. Okay? For as long as the criminal act charged in the complaint or information can be properly identified. Okay? So what is the effect of failure to designate the offense of the statute or failure to mention the provision violated? Anong mangyayari pag hindi mo nailagay kung anong crime na committed? Example, nakalagay sa allegation, homicide. Hindi mo nailagay na the crime committed was homicide. Nailagay mo naman yung element pero hindi mo naisulat kasi meron yun, for. O, what crime? Crime, homicide. Example. Kaya naman robbery, hindi mo nailagay. Here, the failure to designate yung offense by the statute or to mention the specific provision penalizing the act or an erroneous specification of the law violated, okay, it will not vitiate the information if the facts allegedly clearly recite the facts constituting the crime charged. So, yung sinasabi natin, okay, ang pinaka-importante is the recital of the ultimate facts in the complaint or information. Kahit pa walang nakalagay na designation yung offense or kaya mali yung nailagay na offense. Okay, yung designation. Okay, let's just say in the case of Licyayo versus People, GR number 169425, March 4, 2008. In the information, okay, in this case, the information accuses the accused of the crime homicide. Nakalagay, homicide, but does not categorically state that he is being charged with homicide as defined and penalized under Article 249 of the Revised Penal Code. So in this situation, the accused argues that the specification in the information of the law violated is necessary, sabi ng accused. Kailangan yan, kailangan nakalagay, sabi ng accused. And para makonvict siya for the crime of homicide, okay, under such defective information, okay, it will now violate his constitutional rights, sabi niya. Okay? Sabi ng Supreme Court, no. The court ruled that the fact that the information does not specifically mention Article 249 of the RPC as the law which defines and penalizes homicide does not make the information defective. Okay? Hindi porke na hindi nailagay ang Article 249 of the Revised Penal Code, defective na ang information, sabi ng Supreme Court. Okay? There is nothing in the rules of court which specifically requires that the information must state the particular law, okay, under which the accused is charged in order for it to be considered sufficient and valid.